Is the speaker working?
No.
No. Oh, look,
Well,
the
we have
screen is, the video is working. I told our guest, who I'll introduce in a moment, that this was our first time having an event here in this space, so it's we're a little bit of the guinea pigs here, like figuring out how it works. I don't actually know where they are.
I don't know which one's which.
Which one is in this room? Our academic dean, who's also like our tech expert.
A jack of many trades.
Aren't do you have to turn on the mics?
Oh, okay. That would help. Oops. This one, I think, is on.
Is that on?
They're both on.
Let me try
Unmute.
this
Hold on.
one.
Let me. They are muted. One is muted.
How's that? Oh, look. Yeah. Bravo. Ooh, wow,
Hello,
that's
hello?
loud.
Yeah, okay.
You got it?
This one working too?
Yep.
Okay.
Yeah. Is yours as loud as mine?
I don't know, is it?
It sounds good? Okay.
Okay.
Mine sounds really loud. Okay. Welcome, everyone. I'm Michael Santambrogio, the Dean of MSU College of Law, and I'm delighted that you all were able to make it this evening for our conversation with Cecillia Wang, who's the National Legal Director of the ACLU, and I'll have more to say about her in a moment, but I first want to thank everybody who helped to make this inaugural Leader in Law program possible. And first, I want to thank the Marcom's marketing and communications team led by Aaron Richard, and everyone over there who worked on the marketing for this program and many other aspects of it. Also, Cecilia's assistant, Addison Ball, and Akila Clark, my assistant in the Dean's Suite, Brandon Murphy and Nicholas Spike at DPPS for their help with logistics and security, and a big, big thank you to Mark Zabrowski. Where are you, Mark? Raise your hand. Oh no, he left. See, he's doing everything. He's been organizing and overseeing this project from start to finish. And finally, this event wouldn't have been possible without the generous support of Ryan Clarkson, MSU Law class of 2005, and Shireen Clarkson, both of the Clarkson Law Firm. We are grateful for their support for this series. So our guest this evening, Cecillia Wang, is the National Legal Director of the ACLU, where she oversees 200 lawyers and support staff in the National ACLU Legal Department. In addition to that, she works with the ACLU's local affiliates, 54 state affiliates, and leads the ACLU's work in the Supreme Court, which we'll be talking a lot about today. She's been at the ACLU as a lawyer for more than 2 decades. From 2016 to 2024, she served as the Deputy Legal Director at the National ACLU and directed the Center for Democracy, which encompasses their work on immigrants' rights, voting rights, national security, human rights, and speech, privacy, and technology. Before that, she directed the ACLU's Immigrant Rights Project and was an adjunct lecturer at Berkeley and Stanford Law Schools. And we actually met, I think it was during that time, briefly on a conference call, pre-Zoom days. We didn't see each other. But we were each working on a class action involving immigrants and naturalization proceedings. And she had a class on the West Coast, or the Ninth Circuit, I guess, and we had it on the Second Circuit. And so we had a strategy session around that. So it's nice to see you in person.
Great to have
here.
our paths cross again.
Yeah. So she was named to Forbes 50 over 50 list in 2025 and has received numerous accolades, including from the City of San Francisco's Immigrants' Rights Commission, University of Pennsylvania and Vanderbilt Law Schools, Sierra Club, National Lawyers Guild, California Rural Legal Assistance, and the Asian American Bar Association of the San Francisco Bay Area. She has litigated and had positive results, a high rate of success in many notable cases. Most recently, you may have heard her in the birthright citizenship case. I saw a T-shirt there talking about this, Sehi, and that was in the Supreme Court last term, in which she successfully challenged an executive order that aimed to strip U.S.-born children of undocumented immigrants and temporary visa holders of their birthright citizenship under the 14th Amendment. And October 13th, maybe, we'll see, talk about that. She'll be appearing before the Supreme Court again in one of the first cases. It hears this term, if it hears it, and we'll talk about that. Janala, fast-moving, events in these cases. Janala versus Black, in which the government argues that lawful permanent residents in deportation proceedings have no due process rights, including no right to a bail hearing during prolonged detentions, which is something you've probably read a lot about in the news. This has been a new tactic in deportation by the administration. This term, there's a lot of cases that are pending and may be before the court, and we're waiting to hear as the court decides in its conferences which cases they hear. But there's quite a number. Every year the ACLU has a number of cases. So it is my great pleasure to welcome Cecillia to MSU.
Thank you, Dean Cecillia. Thanks, everyone.
So, like me, we talked before, and like me, Cecillia is the first in her family to become a lawyer. We were talking about a little bit about that experience, and I mentioned that almost 90% of the class that we welcomed to campus last week, the first years, are also first-generation lawyers. And we talked about some of that, what that experience was like. I remember my first interview in law school. I shared this story. I've shared it with some others. I came in a green suit, and at the time, I don't know if this is still true, honestly, but like at the time, you were apparently only supposed to wear a very dark blue suit. And someone, as I'm headed to this interview, told me, "Why are you wearing a green suit?" So ironic, isn't it? Given where I am, like I wish I still had that green suit. So, anyway, so we had to learn these things. So what was that like for you? And coming to Yale Law School, which I'm sure can be intimidating, particularly as a first-generation lawyer.
Yeah. So the dean shared that story about the green suit with me, and I had a very similar story from my first job out of law school, where I'm the only lawyer in my family. My parents were immigrants, and on my first day of my first job out of law school, which was clerking for a federal judge in Los Angeles, my uncle had bought me this beautiful leather briefcase. And it was a man's briefcase, like one of those picture Mad Men, right? Like a hard-sided leather briefcase. So I very proudly carried this mostly empty briefcase to work. And my co-clerk looked at it and said, "What's with that briefcase?" And it was, I remember, we're kind of laughing about these moments now, but they are so telling about feeling like an outsider. And I think it's really important to start with this question because I'll be honest, I felt bewildered, alienated. I felt I didn't belong. We could spend a whole hour telling stories about all the ways in which I felt like I was an outsider. And I think, because people who are doing law school admissions, including at Yale where I went, it's a very different law school now. The outgoing dean, the previous dean, Heather Gergen, took pains to make sure that that was a diverse class in every way, not just in terms of the usual demographic factors, so that I think a slight majority of students in the last few classes at Yale Law School are first generation professionals. And I think, there were so many ways in which I was, it was almost like being an immigrant, I think. I'm not an immigrant. My parents were immigrants. I'm a second generation American. But it's like I was dealing with a new language, the language of the law, and starting with the first year curriculum, I remember sitting outside. There's a courtyard where a lot of us would hang out right before class, and we were going to go into contracts lecture, we're all finishing our reading, and I kind of just said out loud to nobody, "What is a writ of assumption?" And one of my classmates looked at me and he goes, "What's not to understand?" You know, like I said, I wasn't going to sit here and tell a lot of stories, but you have to learn a new language. You have to learn, it's a new culture. And I think that's true for everyone. Even those people who, you know, whose parents are lawyers, who seem to know it all and seem to be, you know, fish swimming in water when you feel like a fish on dry land. And I think, you know, part of my experiences as a law student, and for, you know, the first 10 years of my legal career, you know, was about learning to be comfortable in that language. Not only learning it, but being comfortable being in that position of being an outsider. And then gradually you become an insider.
Yeah. Well, what drew you first then to civil rights advocacy? Did you know going into law school that you wanted to do that? Or was it something that developed over time or someone influenced you?
A little of both. I was an undergraduate at UC Berkeley. I'm from California originally, and it's my local school, my local college. And I took a lot of ethnic studies courses, and through those courses, learned about, so this was in the late 80s, early 90s, you know how old I am, and a bunch of Asian American lawyers, just in the past few years at that point, had formulated the strategy to overturn the World War II era conviction of Fred Korematsu, who is one of 3 Japanese Americans who went up to the Supreme Court eventually, challenging either their incarceration based on their Japanese ancestry or curfew laws that applied to people of Japanese ancestry during World War II. And they came up with this very creative legal strategy. Have you ever heard of a writ of coram nobis? Anyone? So a few. This is a law school crowd. So great. So a writ of coram nobis is a way to undo a past wrong, you know, to overturn a past conviction. And they had, you know, figured out that there was this writ of coram nobis, and they went into federal district court in the Northern District of California to file this petition to try to overturn at that point, 40-year-old criminal conviction of Fred Korematsu that the Supreme Court had, you know, upheld. And they won in the district court. They also were part of a larger effort to get Congress to approve reparations for Japanese American individuals who were incarcerated based on their ethnicity. And they also won that battle and got a modest sum for people who were survivors of the incarceration. And that really fired me up. I thought, this is something I'd love to do, to figure out how to right past injustices and you know, part of that litigation and legislative advocacy is about changing the public conversation and trying to perfect this nation of ours that started out with these really fundamental flaws that, as you all know, as law students and lawyers, that were baked into the Constitution. You know, the slavery is baked into the Constitution. You know, all kinds of race discrimination, the treatment of indigenous Americans was baked into the Constitution in various ways. And so the question is, how do we have an ongoing process to try to make this country live up to our best ideals? And that really appealed to me.
Yeah. Well, and you found a place to do it in the ACLU. But I did want to ask you, so you started the ACLU after you clerked, and we'll talk about clerking later. But then you spent some time as a public defender and spent some time at a law firm as an associate in San Francisco before making your way back to the ACLU. And we often talk about how, the first job after law school is far from your last, and you will move around a lot. But tell me what, kind of you learned from those experiences and then what brought you back.
Yeah. So I remember that feeling, which probably the students in the crowd remember, at every job interview, every decision point, what am I going to do for my first job out of law school? Feels like this is it, like this is the rest of my life. So I can relate to that feeling. So I want to start with that caveat. I'll say the job I hold now as National Legal Director of the ACLU is the first job I ever planned on getting. My first job, that's the first job in 30 years as a lawyer that I planned on getting.
You chose the right one.
It is probably my last job too, so it's fitting. I had two rules that have guided me as I've faced these decision points in my career. I have followed people I respect, who I think will be good colleagues and good mentors, good supervisors, and good people to work with. And second is that I tried not to worry about this being the last thing I do. This is what I'm going to do next, and that's it. And I found over time that my anxiety about each of those decision points became kind of receded because I knew that there would be more. Yeah.
That's great. So ACLU, where you have been for quite some time, is one of the largest civil rights organizations in the United States. Founded in 1920 by a group of lawyers committed to defending free speech and anti-war protesters at that time, conscientious objectors. And your sense it's defended many different organizations and individuals in speech cases and other cases on both sides of the political spectrum. Many unpopular people from one side of the political spectrum or the other. But tell us, what is the mission, what is it to you, what is the mission of the ACLU? What is it is it trying to accomplish, and what does it mean to you?
So I think first and foremost is that we stand up for principles of civil rights and civil liberties. We also stand with communities and with individuals, but unlike, say, a legal services organization, our primary mission is to stand up for those ideals in the U.S. Constitution that I mentioned a minute ago. Justice, equality, due process of law, increasingly these days, just the rule of law, that government officials should be held accountable the same way that the rest of us are held accountable when they violate the law. And that sense of principle that we are going to fight for these fundamental rights that are part of the fabric of the founders' vision, flawed as some of the founders were. We believe in their vision, their espoused ideals as you see them in the Constitution, and particularly in the Bill of Rights, and then the Reconstruction Amendments, of course. And so that, in a nutshell, is what we do at the ACLU.
And what's your job as the National Legal Director? What is your job in that?
So as National Legal Director, I am the manager at the head of the National Legal Department, which now we need to update our numbers. We've got about 240 people. That includes both paralegals and legal assistants, as well as lawyers. We've got a couple other people who do other kinds of advocacy, but we're mostly a litigation shop. So that's one big part of my job. I'm also part of the senior staff of the National ACLU, so I am working with my colleagues who are in charge of the political advocacy department and our communications department. I work with our executive director, with our fundraising department. So we are working as a team across those various functions to make our organization the best that it can be. And then third is I'm in charge of our Supreme Court docket, which I know you want to talk about. And that has become an overwhelming part of my job as our Supreme Court docket has burgeoned over the last couple of years. So, yeah.
So okay, well that's a great segue. So, so why has it burgeoned over the last 2 years? I mean, I guess let me ask it this way too. I feel like we're living, and the title of this talk is a time of constitutional change. But some people will maybe debate that whether there really is greater change in the court now than before. But I feel like we're seeing bigger precedents dropping, kind of like flies. Sometimes with warning, sometimes without much warning. Fortunately, the birthright citizenship did not drop. That would have been kind of without warning. Yesterday, the court, they took they're taking a wrecking ball to my area of constitutional law, which is the structure, and they, overturned a standing precedent for that was pretty settled, but I guess they're always kind of inconsistent with standing. But do you think that this is, would you agree with that this is a time where the court seems to be shifting dramatically in terms of its constitutional interpretation?
100%, yes. I think a majority of the court is very interested in history and tradition as if not the only guide to interpreting the Constitution, their primary mode of interpretation. That is very different from the court over, even the court I clerked on in 1996, 97. It was very different. We could talk about different ways that kind of comes to the fore. I think there are two trends, to get back to your first question, which is why are we so busy in the Supreme Court? I think there are two reasons, and one might be a surprise to some of you. The first reason is the obvious one. The ACLU, more often than not, is the respondent in the Supreme Court, meaning we won a case in the lower court, in the U.S. Courts of Appeals, sometimes in the state Supreme Court, and our opponent has asked the Supreme Court successfully now to take the case. And so we are the victims of our own success. We have gotten ourselves very busy in the Supreme Court because we've been very busy winning cases in lower courts. The second reason we're so busy, which is maybe the one that would be a surprise to some folks, is this new court, with its new, shifting dynamics, shifting modes of constitutional interpretation, and sometimes because of their shifting sort of institutional practices like the emergency docket or different approach to stare decisis, those give us opportunities to make progress. And this relates to what I said the mission of the ACLU is. Because we stand for principle, we look for opportunities where we can advance those principles with people who, some progressive civil rights organizations aren't in a position to do. So for example, the ACLU was counsel on the side of the Second Amendment in a case this past term. I got us on that case because as a former federal public defender, for a couple of reasons. As a former public defender, I have long been of the view that a federal criminal law that was at issue in this case, United States versus Hemani, is a very bad law that violates the federal prosecutors use to violate people's rights, and that is a significant driver of over-incarceration in this country. What's the law? It's a federal statute, 18 U.S.C. 922 G3, which makes it a federal felony to possess a firearm if you are, and I'm going to quote here, an unlawful user of a controlled substance, or you're addicted to a controlled substance. We jumped into this case at the Supreme Court level on behalf of our client, Ali Hamani, who was prosecuted under this federal criminal statute simply because his parents' home was being searched. That's another part of the story I may or may not get to. But the federal government for many, many years had been investigating his family without finding any evidence that their family had ties to terrorist organizations outside the United States. So the FBI has been investigating them for many, many years, and they got a search warrant to search Ali's parents' home. When they arrived to execute the search warrant, Ali is very cooperative. They ask, of course, as police do when they're searching your home, do you have any firearms or any dangerous weapons in the home? And he said, we keep a gun for protection. It's locked in a safe. And he shows them the gun. And they ask, are there any illegal drugs in the house? And he says, I smoke marijuana about twice a week, every other day or a couple times a week. And based solely on that admission that he smokes marijuana a couple times a week, they then charge him with this federal felony. And so the case makes its way up to the Supreme Court, and I said, we want to be on this case. Number one, in the Second Amendment context, as the lawyers in the room know, the Supreme Court completely uses a history and tradition analysis. All they care about is, was there a history and tradition at the time the Second Amendment was ratified of this kind of regulation of firearms? If the answer to that is no, then that new regulation violates the Second Amendment, okay? So we knew that this court, if it takes the history and tradition mode of constitutional interpretation seriously, should actually affirm the U.S. Court of Appeals for the Fifth Circuit, which had struck down the statute as applied to marijuana users. So that was a chance to use this court's preferred mode of constitutional interpretation in a way that would strike down a federal criminal statute that's a significant driver of unfair criminal prosecutions, and that is a major driver of incarceration rates, where people are actually not dangerous. Excuse me. So that's, sorry, what I mean by an opportunity.
Yeah. That's great. So, so are there any other areas? So I always think of the challenges that you face as a respondent with this court. But are there other areas like that where you see opportunities?
Yeah, it's funny. Birthright citizenship was one of them.
Yeah.
Excuse me. So in birthright citizenship, I'll just tell you, this anecdote will tell you in a nutshell what I mean. I did 7 moots, 7 practice runs for that Supreme Court argument. That's an unusual number. It had been a long time since I had argued a case in the Supreme Court, or any court really. While I was deputy legal director, I was not in court. So it had been 7 years since I had a court argument. And I hadn't been on this case in the lower court, so it was new material to me. So we set up all these moot courts, practice runs, with a lot of conservative Supreme Court lawyers, because you want to make sure you have people who reflect the views of the majority of the Supreme Court. And so there were lots of conservative lawyers who very generously offered to help and moot me. And one of them said during one of the moots at Howard Law School, she kind of like, after we were just doing the debrief, she said, this is such a weird case because the Trump administration is up here arguing policy and the ACLU is arguing original meaning, right? And so, yeah, the birthright citizenship case was one where we had history and tradition on our side. And we had precedent on our side since the Supreme Court had decided this issue in 1898. And so, you know, those are cases where we are trying to be responsive to the things that majority of this Supreme Court cares about, and advance toward our goals using their preferred modes of interpretation.
Oh, that's great. So are there other things you think about when you're thinking about the case to take besides kind of how their mode of interpretation will work, if history and tradition on the issue will work? How much do the underlying facts of the case matter when it gets up to the Supreme Court?
Yeah. Well, you're not in control of that anymore by the time it's in the Supreme Court, so sometimes you just have to take what you get. And it's interesting. So one thing I want to say is I gave you an example, U.S. versus Himani, where we jumped in the case at the Supreme Court level. But, you know, the vast majority of cases that the ACLU has are cases we brought in the trial court level. So they've often been ongoing for a long time. They're often part of a longer term strategy. And I think that's important to remember because, you know, coming out of the immigrants' rights work, as you do too, at least in part, you know, people started saying Dobbs, the case that reversed Roe versus Wade, of course, is a case most people think of when they think of this court as it's constituted now. And that was an earthquake for all of us as the court abandoned a precedent about a fundamental individual right that had been in place for 50 years. And so a lot of people who, you know, maybe focus on reproductive rights and abortion rights, you know, would say things like, oh my God, the Supreme Court's against us. And, you know, same thing with LGBT rights, right? Where this court, the previous court, you know, with Justice Kennedy on it, who had, you know, been a champion for LGBT rights, or at least LGB rights, you know, we're worrying that the court is now much more hostile than it has been as currently constituted. As someone who comes out of immigrants' rights and public, you know, as a public defender, the Supreme Court's always been hostile, right? It is worse now from a civil rights, civil liberties perspective. It's certainly worse than it was, more hostile than it was. But you know, so much of our work has always been keeping cases out of the Supreme Court. How do you bring cases that you know, are not going to reach the Supreme Court? That has been it's increasingly difficult to do, but it is still part of our strategy. And the reason I think it's important to remember this is, you know, last term, or now 2 terms ago, you know, we lost a major case in the Supreme Court, Scrimeti, which was our first transgender rights case in the Supreme Court. We lost another one this past term. But in Scrimeti, it was the first time we lost a major transgender rights case in the court. And the issue in Scrimeti was whether a state legislature could ban gender-affirming care, essential health care that a person's medical providers and family had all agreed on, where they could ban that essential health care for transgender youth, for teens. And these were all cases where the doctors and the parents and the teen all agreed this was essential medical care. And this was all, you know, by the time the case was decided in the Supreme Court against us, 26 states, more than half the states, had passed laws taking away essential health care for transgender youth in this country. And all the, you know, Monday morning quarterbacking started after we lost that case, which, by the way, was not a surprise to anybody, right? We were respondents in the case. We had won the case. We had won all of our cases challenging similar state laws in the lower courts. And then the Monday morning quarterback said, "Why did you bring that case to the Supreme Court?" you've now made bad law, blah, blah, blah. So first of all, we didn't really make bad law because the opinion actually was quite modest and didn't say, for example, transgender people don't have the same rights under the Equal Protection Clause as everyone else. That was a concern. The Supreme Court did not do that. They said this is a healthcare regulation. It's not a regulation based on transgender status. So it was a good way to lose that case, and an outcome we had been hoping for in the loss column. And what I said to the Monday morning quarterbacks was, first of all, we didn't bring the case in the Supreme Court. We brought these cases in lower courts because more than half the states took away essential health care from people in this country. And if to the people who are saying you just made bad law in the Supreme Court, if we didn't bring those cases, the bad law would be the 26 state laws on the books that took away people's health care, right? And so when you stand up for these fundamental principles of civil rights and civil liberties, you do it because, we've got an emergency on our hands. Increasingly, you think about what the ACLU did in litigation, 20 years ago, 25 years ago, 30 years ago when I started, we rarely did emergency litigation. These days, we have to go into court and try to get a preliminary injunction or a temporary restraining order to prevent someone from having their health care taken away, from having to find a way, if they can afford it, to go to another state for their health care, to prevent the President of the United States from declaring people not to be US citizens based on his new interpretation of the 14th Amendment. And so, we bring these cases in lower courts. We try to be strategic about it. I think we are strategic about it. And in the vast majority of cases, we are trying to keep the case out of the Supreme Court. And then we also have a strategy for winning the cases that eventually end up in the Supreme Court.
So that leads to my next question, because that's a great kind of a description of how you think about these different cases, where you have opportunities where you're defensive, where you have to bring the case, where even when the Supreme Court may not be the most receptive court right now. But then, when you're in the case, and history and tradition is not on your side, what's the strategy there? And Gennaro, I noticed looking at that, you opposed, obviously, the petition for cert because you didn't think it was going to go well there. And maybe you can talk about whether that case is going to go to the court or not still. But then how do you approach that in a case like that?
Yeah. Well, we are making history and tradition arguments in Gennaro the best we can. So, for those who are not constitutional lawyers, the history and tradition analysis basically says, at the time this constitutional provision was ratified, what was the practice? I explained it a minute ago, but that the time period is relevant. So there's some argument about what time period is relevant, but generally these justices think it's when this provision was ratified. That's why in the birthright citizenship case, the question was, what did everyone think the citizenship clause meant in 1868 when the 14th Amendment was ratified? Set aside the fact that, the majority of us were not considered to be citizens. We're not fully considered to be citizens at that time, but that's the question they want to ask. So, you answer that question. So Gennaro versus Black or Gennaro versus GM, let me take a step back and explain what the case is. 1996, Congress enacted, they really revamped the whole immigration law, and one of the things they did is for the first, well actually they first did this in 1988, but 1996, Congress basically ramps up in a serious way the idea of mandatory immigration detention, which means that for people who are contesting the the government's deportation case. They're going into immigration court to say, I'm not deportable, actually, or I have a statutory right to stay in the United States. While those people are fighting their cases, the government locks them up in ICE jails without a hearing on whether they're a flight risk or a danger. So the equivalent of this would be in criminal cases where we're all familiar with being released on bail while the government's accusing you of a crime. In the immigration context, Congress decided for vast numbers of people, you're not even going to get a bail hearing. We're just going to lock you up based on the fact the government's accused you of being deportable on a certain ground. And so the ACLU's been challenging those statutes. We started immediately after they were enacted by Congress in 1996. 2003, we get a case up to the Supreme Court. Actually, the government gets a case up to the Supreme Court. We were the respondents because we had won below. And the court says, upholds that statute, one of the statutes. This particular statute is one that makes people deportable without a hearing if they have committed any one of a vast number of crimes Congress has labeled an aggravated felony, which is really a misnomer because very minor crimes like shoplifting can qualify. And it doesn't matter if in your criminal case, you got a sentence to probation. And so clearly the criminal court thought this was a relatively minor offense. Congress labeled all these things aggravated felonies and subjected people to mandatory detention. And the Supreme Court said in this 2003 case, that's okay because relying on information the government provided, which turned out later to be false, as the government admitted, the average length of detention for people detained under this statute is only about 5 months. And so for that brief period of detention, we are going to approve of this mandatory detention statute because Congress can presume that everyone who is deportable according to the government based on one of these criminal grounds categorically presents a flight risk or a danger of committing new crimes. Okay, so we lose that case. Ever since 2003, we've been back in court trying to limit mandatory detention based on the length of time that people are locked up. We've had clients locked up for 4 years just because they're fighting their deportation case. And I will tell you that the data shows that for people who've been detained for years, those are exactly the people who end up winning the deportation case at the end, because otherwise they would give up and just be deported. So the vast majority of people who are subjected to prolonged mandatory detention under this statute are green card holders who have a criminal conviction, who have every incentive to keep going with their deportation cases because they're going to win them at the end of the day. Ginalo versus GM is the next case raising the constitutionality of exactly that immigration statute the court approved in 2003. And in this case, the question is there any time limit on how long ICE can lock someone up without a hearing? It's not about whether there's they have to be released. It's just give me a hearing so I can show an immigration judge I'm not a flight risk or a danger. I'll keep showing up to court. And the government, this administration is taking a really radical position on the due process clause issue that is the government has never taken before in 30 years. They say that people in our client GM's situation do not have a protected due process right at all. Let me say that again. People who are locked up by the federal government have no due process right to not be locked up. It's pretty extraordinary. There's a reason why the government, even in this case, the government below didn't take that position. They admitted that there was at some point, when detention becomes very prolonged, so they got to give people a hearing. They said that in the lower court in this case, and now are saying no.
Why do you think they're going for that maximalist position now? It doesn't seem like a good winning argument.
I think their calculation is they can win on that theory in the Supreme Court. We'll see.
Yeah.
Or maybe not.
Okay, well, let me just maybe shift gears for a second.
Yeah.
So you mentioned before you clerked on the Supreme Court,
Yeah.
and you actually have the distinction of having clerked for 2 justices, kind of at the same time, one term, I know.
Yeah.
But Justice Blackmun, who was retiring, and Justice Breyer, that's right, who was just coming on the court. So we talk a lot about clerkships with our students. So I was just talking about it today with some students, encouraging them to consider clerkships. So tell me, what was that experience like for you? What do you learn from that experience as a clerk? And what did you learn from clerking on the Supreme Court that you still helps you today?
So the truth is that my experience clerking both on the Supreme Court and in the Ninth Circuit was very similar, unfortunately, to my law school experience. I felt like an outsider. I felt bewildered. I felt like I was struggling to keep up, and I had all those feelings we know as imposter syndrome. So it was tough, but it's a crapshoot. Let's face it. It's so hard to get a clerkship. But if you're lucky to get one, I always recommend to our law student interns, like, apply. You should go for it, because I'll tell you the most valuable thing. Like, there are lots of doctrinal things that you learn that will serve you well. If you clerk on a district court, you can have the fun of bossing around lawyers who have been practicing for 30 years. Well, they call you for an extension of time, and you hold their futures in your hands. But I learned that there's such a range of ways of lawyering. And, there were so many times where I would think to myself, oh, I can do that. Like, sometimes I think, oh my God, that person did not do a good job. I could definitely do better than that. But more important, there's such a range of ways of lawyering, even just limited to the appellate context. You can find a style that is right for you, and you see how different people do the same job in so many different ways. So that's one. The second thing is all the judges that I worked for were extraordinary judges, and I learned so much from watching them be a judge, and that gives you insight into how you want to show up in court to persuade the judges.
Yeah. I listened to your oral argument in the birthright citizenship case, and as I told you, I was just so impressed with how you did, and I never would have known that it had been 7 years since you've been arguing in a court. So obviously a lot of preparation went into that. You mentioned the 7 boots, which is something. But for me, what was so compelling is that you had this great conversational style. I think we've seen it here too tonight. But with the justices, whereas the Solicitor General was kind of very, almost felt like he was antagonistic toward the justices in a way, like trying to state his position. But you kind of had this conversation with them, almost like we were in this room. What do you think makes what are the traits of great oral argument?
Yeah. I think it depends on who you are as an advocate. But I think for me, and not only arguing, but also watching other people argue, I think when you have a conversational style, when you approach this as, I'm here to try to help you. I'm here, that was another, maybe a third thing I got out of clerking is, I'm approaching the justices as I would if I were their clerk. But more experienced with more gray hair. But The justices are wrestling with things. Sometimes they're wrestling with, how do I make you lose? Certainly don't want to help them with that. But, I think, first of all, I have to have that style because otherwise my anxiety would be unbearable, right? Like, I'm not here to tell you the answers. You judges are the ones who are going to decide what the answer is. I'm here to answer your questions, to try to, clarify things that may not be clear. And obviously, above all, I'm there to try to win the case for my client, or, do harm mitigation for our clients. But yeah, I think there are just different ways to approach it. I'll tell one little story, which is when I was a public defender, I was in trials, I was an appellate defender. My boss, I told you the story, my boss, supervisor of the trial unit in the Southern District of New York, had a signature thing he did in trials. During closing argument, he was a very emotional guy. He wore his heart on his sleeve, just a wonderful person. And he would, at some point in the closing, and this was not a shtick, it was genuinely how he was expressing himself in closing arguments. He would almost always put his hands on his client's shoulders and say, the government is wrongly accusing John of this terrible thing that he didn't do. And he would start crying. I was a 28-year-old Asian American woman. Who thinks it would have been a good thing for me to do that? In my closing arguments? No. So that's what I mean when I say it depends on who you are. Yeah.
Find your own style. You'll see lots of examples out there, but find things that work for you. Yeah. So one last question that occurred to me from that discussion with the court, the argument with the court, is a lot of times people talk about focusing on particular justices, whether it's a swing justice or not. Did you have particular justices you were trying to reach in that case or in other cases?
Absolutely.
Yeah.
Every Supreme Court advocate, every appellate advocate, every trial court advocate, you need to tailor your arguments to the person who's deciding the case. And so everyone goes into a Supreme Court case, not just the argument, but the briefing, even more important, with a way of how, in the Supreme Court, how am I going to get to 5? How do I get to 5? And you got to figure out who, the fourth and the fifth vote is, or however many it is that you think you need to make up. And you are reading their previous decisions that might be relevant. You're talking to people who've appeared in front of the court. You're talking to people who clerked for those judges, and to try to get an insight on what is going to appeal to this person.
Right. So let's maybe share some advice with our students who want to pursue public interest careers. We have a fair number that go into public interest careers here every year, but what would be your advice to them and how to start down that path?
Yeah, you start by starting, intern with an organization you admire. These days, you guys are lucky because you can intern remotely a lot of the times. When I was in law school, you had to work there and show up in an office. So you have a wider range of organizations you can intern with, whatever clinical programs you have available. I got through law school because of both interning, working. I wanted to get to it. I went to law school to be a lawyer. I, frankly didn't go to law school to sit there reading about writs of assumpsit. And so, I think you just do it. And, everything is about relationships. And I don't mean that in the sense of like, you should be networking and this is like what's someone gonna be able to do for me in the future. When you work with people, you build relationships. Like, Dean Santambrogio and I worked together so many years ago, like more than 20 years ago, on these cases. So you form these relationships that are lasting and where you you will be able to cross paths later on and do work together again.
That's great. So I want to give the audience an opportunity to ask some questions in some of the time that we have left. So does anybody have, and we have a microphone in back that Aaron is going to take around. Yeah.
Hello.
I'm Sadie Jordan. I'm at MSU Law. I interned with NAACP this past summer. So
All right.
I'm very much civil rights focused. And my question is, it's such an interesting time to be in law school right now because of such sensibility, right? Like we're reading common law cases and then you go home and it's like they don't matter. So you're like, okay, cool. Just read that 60-page opinion for nothing. So considering that, like the role of law students right now is limited in the, we can't represent clients or bring suits, but we have the knowledge and skills that we're building. So as someone who is doing the work retroactively, what do you think law students' role should be at this moment, right? Beyond like clinic, immigration clinic and doing that work, but like being advocates on our campus, I guess?
Yeah. If there's one thing I've learned in 30 years doing this, it's that we need to set really long-term goals, and it involves not just winning lawsuits, but shifting public opinion in this country so that we don't have people elected like Donald Trump, and that Donald Trump and people like him don't have political incentives to do the things they do. They do those things because they believe that they have enough constituents who want them to do it that it makes it worthwhile for them. And so all of you who are just starting out on this road, I'm on the other end of 30 years looking back, like know that you have so much power, not just as a future lawyer, but as a person living in this country to be part of, we're all putting, Dr. Martin Luther King talked about the arc of the moral universe being long but bending toward justice. It's like we're all we've all got our hands on this big lever trying to bend that arc. And so we all do that. And you nailed it. There are things you can do on campus. There are things you can do within your family and your social circle. I have an aunt who's pro-Trump. I try not to talk to her because I have found it's useless. But I keep trying with those folks because eventually, and birthright citizenship was a great example of this. There are so many immigrants who were okay with the things that Trump did in his first term, many of which, by the way, President Biden continued during his term, who are okay with it because it seemed to land far from home for people. But then you get to birthright citizenship, or you get to temporary protected status, Mullen versus Doe, which we didn't talk about. And suddenly people are saying, wait, we're citizens. Wait, we're here legally. And you see, these things are all related. So I think being part of that story, trying to help people see the relationships between our communities, people have a hard time with transgender youth. That's a hard issue. And a lot of people of goodwill, were not with us on that issue. And so part of it is trying to have that conversation, basically, and get people to understand why these are important issues, not just for those families who have trans teens, but for all of us who care about our country living up to its ideals.
Thank you.
We've got another good. From there.
Hi, I'm Sam Wright. I'm a 1L here. I was wondering, not including your recent Supreme Court cases, is there a case that stands out in your career that maybe taught you the biggest lesson, and if so, what was that?
Yeah. The one that comes to mind, I'll mention two briefly. They're both out of Arizona. In the 2010s, Arizona was leading the country in anti-immigrant legislation and state executive policies. So one of the cases was a case called Lopez Valenzuela versus Arpaio, where we were challenging an Arizona state constitutional amendment known as Prop 100 that made people that the state determined to be undocumented immigrants ineligible for bail in criminal cases, applied to thousands, literally thousands of criminal offenses, criminal laws under the Arizona Penal Code. I lost that case at the motion to dismiss stage. I lost more of it at the summary judgment stage. Appealed to the Ninth Circuit, drew a terrible panel. I lost it in the Ninth Circuit. I was like, what is wrong with me? This law is so unconstitutional. I should not be losing this. And eventually we won it in the en banc Ninth Circuit. And so the lesson I drew from that is, so, that old saw they say about Abraham Lincoln, like running for election like 50 times before he won. Like, don't give up. Second case out of Arizona is another case against Arpaio, then Sheriff Arpaio, which was our class action challenging racial profiling of Latinos in Maricopa County. And the lesson there was that as a lawyer, a civil rights lawyer, you're a little piece, little gear, whatever, cog in a bigger effort to achieve a result. The ability of Latinos or people who might be mistaken as Latino by a cop, the ability to leave the house without being afraid you're going to get pulled over and abused by a sheriff's deputy. And the reason I say you realize it's a small cog is that case came about because Latino grassroots leadership in Maricopa County, the sole Latina member of the Board of Supervisors of the county, the heads of various grassroots organizations, saw the need. They had a plan. They had a plan to change the county and its policies over time, but they needed lawyers to come in and almost literally get the jackbooted thugs off their backs. And they came to the ACLU of Arizona and MALDEF and said, we need you to come and bring these lawsuits. And we did. And then over time, those same grassroots leaders were responsible through their organizing efforts. And I should make the caveat here, the ACLU is nonpartisan, we're not, but those other organizations and individual leaders ultimately were responsible for flipping Arizona's Senate seat and for ousting Sheriff Joe Arpaio, who had served in office for more than 25 years. The lawyering is a piece of a larger strategy. This gets back to your question too, that should give you hope, because these things take time and they take a lot of people all trying to pull in the same direction.
That's great.
Yeah.
Yeah. We have another question up front here. Yeah.
Hi, my name is Natasha. I'm a 1L. One of the conversations that has come up pretty frequently in our first week-ish and a half of law school has been about balance. And as I'm sure many of my peers are here, I'm interested in pursuing a career in public interest in civil rights work. I was wondering if you could touch a little bit on dealing with the emotional burden that comes with doing this type of work, especially in a time where it is very polarizing and a big topic in the public sphere.
Yeah, so that's a great question. And luckily, people your age are much better at this than I am, than people my age are. So you tell me is how I want to. Look, we have to to be able to do this work over 30 years, to be able to do this work over 1 year, you have to find support in community. You have to have long-range vision. So it's the losses as they come are okay because you put them in context, that I've got my eyes on the prize. That could be 30 years down the road, could be 50 years down the road. And we have to find ways to rest and be joyful and laugh about things, however that, whatever works for you. And so I, started off with a sort of, not really a joke, but people who are new in the civil rights organizations, including at the ACLU, are the ones who tell people, like Gen X people like me, like this is, a generation gap stereotype, but I think it's true. Like I think people who are younger, understand that better and have been really instrumental in changing institutions in order to pay attention to this, because we need people to be in this for the long haul. And so I think, putting losses in perspective. As a public defender, particularly when I was in the Southern District of New York, where the U.S. Attorney's Office has something like a 98.5% conviction rate, because they only bring really strong cases, you have to redefine victory. It's not a not guilty verdict. You can redefine victory as, I stood up with my client and I did the best I could. And he knew that I did the best I could and that someone was standing up with him, even though he was convicted and, had an unfairly long sentence. So all of those things are important. Yeah.
That's great. Yeah, one more. I think there's that in the back.
Aged law librarian.
Librarians are the best, thank you.
My question is about the Birthright Citizens case, and I wasn't surprised that it was won. What surprised me the most was it was not unanimous. So there is ambiguity in the 14th Amendment. Reading it today. Most people don't know there's 5 parts to it, but there's plenty of ambiguity. There isn't any ambiguity in the first sentence about those born in the United States or citizens of the United States. So how could there be objection or originalists or traditionalists? Why wasn't it unanimous?
Yeah. I mean, why, how do people get on the court? I think that's what it, it's a good question. My first reaction is, I'll confess I was surprised it was 5-4. It's not exactly 5-4, since, Justice Kavanaugh would have struck down the executive order on statutory grounds, and Justice Gorsuch thinks that the children of undocumented immigrants should be citizens, but not the children of temporary visitors. So, I don't know, it's like 6.5 for affirming on some ground. But I was surprised. I thought before argument, there were a lot of people who thought it would be unanimous. And I said, no, there's no way. I just didn't think that was going to happen. But, I do think there were justices who signaled that during argument, they sent positive signals, I think, and then, disappointed us. And so the important thing to me is that regardless of the vote count, that majority opinion ruled on constitutional grounds. Because one of the win scenarios that I thought was going to end up being a loss scenario for us was if a majority of the court struck down the executive order on statutory grounds, because then Congress could go and change who's a citizen. So I think, there are certain people I heard say, this was like the Susan Collins effect, that when they knew that there was going to be a majority opinion upholding birthright citizenship and striking down the executive order, they could, for whatever reason, write an opinion saying what they said. Who knows? I don't know the answer.
You can ask her about term limits for the Supreme Court in the reception afterwards, but not on the official program. We have one more question, one more up front here.
Thank you. My name is Jack. I'm a 1L. I wanted to ask you about hope from your vantage point in the long term, maybe beyond, say, a different administration or court structure or court personality. What do you think the industry, what do you want the industry to look like of public interest and civil rights work maybe 10 years from now in the long term? And to say it another way, maybe where should people that care about it be looking to work, and what kind of work should we be looking to do?
Yeah,
That's great.
such a good question. You know, I'm of the view that this work is never done. You know, there are always going to be these struggles where you have politically vulnerable minorities, you know, Chinese, people of Chinese ancestry in 1898 and today, transgender youth today. You know, there's always going to be some scapegoat community that people find it politically expedient to pick on through policy making and lawmaking. And so that's just a fact of life, I believe. And so I think that this work is not about you know, winning something once and for all. We should have learned that lesson through Dobbs, right? Or name your precedent. Calais, another case we had in the court this past term we didn't talk about, where long-standing civil rights protections were, you know, undermined, devastated by a Supreme Court decision. So I hope and believe that there will always be people fighting to keep on perfecting our national, you know, community. There are always going to be people who are fighting these battles. You know, when Donald Trump won election this second time, you know, you got to find where, take hope wherever you find it. I went to read James Baldwin, which I did the first time he won too. Trump won too. People, another book I'll recommend is Devil in the Grove. I don't know if y'all have read that. It is an incredible story of one of Thurgood Marshall's early cases, less known cases, where he and other black lawyers went to defend these black men who were accused wrongly of raping somebody. And Thurgood Marshall, they'd go to court and fight out in court all day, and they would literally be running from the Ku Klux Klan who are trying to kill them after court. I don't have to deal with that. And so people who are ancestors in this work confronted much harder challenges, building the road we walk on now, and at much greater personal risk. Not to say there aren't people today who are doing civil rights work who are taking personal risks. That is definitely true. But the progress that that our ancestors made, we are enjoying now. And you all will keep it going. Excuse me.
Well, that's a great place to segue, not end. We haven't exhausted the conversation. We have run out of time here, but we have a reception next door, and we can continue the conversation there. So join me, please, in thanking Cecillia.
Thank you. Thanks, everyone.
So I hope also you can join us for our next Leader in Law on Monday, October 12th. Richard Pildes from NYU Law is going to be talking about the Voting Rights Act. He's a national expert on the Voting Rights Act and the impact on the midterm elections, which will be coming up shortly after that. So we'll be continuing this conversation about democracy then. But again, thank you so much.
Thank
This
you,
is a
Dean
terrific
Santambrogio.
conversation.
It's a pleasure. Thank you.
And please, all